Good morning, this is your Kelso Report for Wednesday, June 20th. I'm your host, Clark Kelso. We've got quite a few Ninth Circuit Court of Appeal decisions to go through today. First, a habeas corpus decision involving possible early release regulations. In Peck v. Thomas, the habeas petitioners were statutorily eligible for early release from prison in exchange for the successful completion of a residential drug abuse treatment program. However, the Bureau of Prisons enacted a regulation disqualifying them from the early release incentive on the basis of their current convictions for being felons in possession and one of the petitioners' past convictions for robbery. The petitioners each filed for a writ of habeas corpus asking the district court to invalidate this broad regulation under Section 706 of the Administrative Procedure Act. The district court dismissed and the Ninth Circuit affirmed. The Bureau of Prisons had once before tried to promulgate this regulation, and it was struck down because the Bureau did not provide in the administrative record any justification for it. This time, however, the Bureau explained that the commission of such offenses as homicide, forcible rape, robbery, aggravated assault, arson, and kidnapping rationally reflects the view that such inmates displayed readiness to endanger the public. Therefore, these are not people who should be subject to early release programs. With this minimal explanation, the Ninth Circuit affirmed the regulation and then affirmed the denial of habeas, citing lack of jurisdiction. Next, we have another habeas case involving a claim of actual innocence. The petitioner in Marrero v. Ives filed a petition for habeas corpus pursuant to 28 U.S.C. Section 2241 instead of pursuant to Section 2255. Now, a Section 2241 petition, if proper, avoids many of the procedural obstacles that inmates face with an ordinary Section 2255 petition. 2255 has been amended by the Anti-Terrorism Act. In this case, the petitioner had previously filed a Section 2255 petition challenging his federal conviction, and that petition was denied. The petitioner failed to appeal that denial in a timely manner, so his federal habeas claims are now procedurally barred. Under Ninth Circuit law, a Section 2241 petition can be appropriate under what is known as the escape hatch when the prisoner makes a claim of actual innocence and has not had an unobstructed procedural shot at presenting that claim. The panel concluded that the petitioner did not provide any factual support for the claim of factual innocence of the crime, and his claim that a sentencing enhancement as a career offender was unlawful did not qualify as a claim of factual innocence. Accordingly, the Ninth Circuit affirmed the district court's action in treating the Section 2241 petition as though it were a Section 2255 petition, and then dismissing that petition for lack of jurisdiction. Next, a criminal sentencing case involving sex offenders. The defendant in United States v. Becker pled guilty to knowingly taking or receiving obscene matters from an interactive computer service. That's a crime that does not categorically constitute a sex offense, as defined by the Sex Offender Registration and Notification Act. But at the change of plea proceedings, the defendant stated, quote, "I believe that I am guilty of the charges, and did download child pornography or possess child pornography during the time said," close quote. The district court had sentenced the defendant to a 60-month custodial term followed by 3-year supervised release. The district court had imposed several conditions of supervised release, including a requirement that the defendant complete a sex offender treatment program. Well, after completing his custodial sentence and beginning the supervised release, the defendant violated the terms of the release by, among other things, not attending that treatment program. So the district judge revoked his release, imposed a 9-month custodial term, and then ordered the defendant to register when he was released pursuant to SORNA. The defendant appealed the imposition of the registration requirement, arguing that the court had failed to make the necessary findings in support that he had been convicted of a sex crime. Well, the Ninth Circuit affirmed, reasoning that the admission made by the defendant at the change of plea hearing that he had downloaded child pornography made it perfectly clear that he was required to register under SORNA, under the Ninth Circuit's modified categorical approach, even though the crime he technically had been charged with did not categorically constitute a sex offense. He disclosed a little too much information at the change of plea hearing. Next, we have a case involving a default judgment in Garamendi v. Hennen. The Ninth Circuit affirmed the district court's non-substantive modifications of a prior default judgment entered against a French corporation, such that the judgment could be enforced in a French court. The corrections to the judgment were made pursuant to Federal Rule of Civil Procedure 60, and since the corrections only clarified the original intent of the judgments and did not alter their substantive content, the Ninth Circuit held that the defendant's prior failure to challenge the default judgments constituted a waiver of his current arguments as to set-off, release, and the nature and amount of his liability. So the plaintiffs are now back off to France to collect on their judgment. Next, an interesting labor law decision down in San Diego. As you know, the city of San Diego and its represented employees are locked in battle over a pension reform initiative that the voters approved at the June 5 primary. Well, litigation actually had begun even before the pension reform initiative was approved. In fact, as soon as the initiative qualified for the ballot, the San Diego Municipal Employees Association filed an unfair practices charge against the city with the Public Employment Relations Board, PERB. The board issued a complaint against the city and ultimately filed an action in Superior Court seeking to enjoin having the initiative appear on the ballot. The Superior Court denied that request for an injunction. And when PERB then assigned an administrative law judge to the case and they set a hearing date, the city cross-complained in the Superior Court for an injunction to stay the administrative hearing, which the Superior Court granted. In its decision yesterday in San Diego Municipal Employers Association v. Superior Court, the 4th District granted PERB's request for a writ of mandate directing the Superior Court to vacate its stay of the administrative proceedings. The long and short here is that PERB clearly has initial exclusive jurisdiction over the unfair practices claim, and the Superior Court seriously overstepped its jurisdiction by granting a stay of PERB's administrative proceedings. The city must exhaust its administrative remedies before it gets to come to court. Finally, in Rickards v. United Parcel Service, the 2nd District held that a complaint filed by the plaintiff's attorney through the Department of Fair Employment and Housing's online automated system was sufficient under the Fair Employment and Housing Act to satisfy the jurisdictional requirement that a verified complaint first be filed with the department before a complaint is filed in the Superior Court. There were 2 issues or problems with the online system. First, the complaint was filed by the attorney rather than by the complainant. But the Court of Appeal has previously held that a FIA complaint can be verified by the attorney instead of by the client. Second, the online system did not require a signature, although the language on the filing system clearly indicated that by clicking to file, the document was being filed under penalty of perjury. The 2nd District held this was sufficient, in a victory of practicality over technicality. And that's it for today's Kelso Report. Have a great day in the law.